Welcome to Behind the Bar. Thank you so much for doing this for us. This is the first time I'm sitting in front of a judge, and I think for the right reasons. So,
Right reason, yes.
so for my first question to you is, what inspired you to pursue law in the first place?
My grandfather was a judge. My father was a lawyer, and he gave up a huge practice just to accept an academic assignment. And he started the first time he started the law college under the government in Karnataka. It was an obvious choice. I was selected in the Indian Police Service in 1951 or 52, and there was other options. But this was an obvious professional opening for a young. I became a lawyer when I was 21.
Okay.
So, looking back, I didn't do very badly either.
Do you remember the specific incident which made you like the profession or choose this profession? Any specific moment that triggered that?
Yes. In those days, there was tumultuous changes that were going on in the judiciary in the state. There was a committee constituted by the government, endowed with the powers of a rival high court. The debate was exciting. The matter was challenged in the court, whether you could have two high courts in the same state. Very interesting questions used to arise in the wake of the advent of the Constitution. For the first time, we had an expansive judicial scenario, very expansive scenario where jurisdiction of the court underwent explosive changes. And 50, 51 were very interesting years. I became a lawyer in 51.
Okay.
And I've seen the Supreme Court ever since its commencement. I was in the Prince's Chambers, in the old building. And I've had the privilege of watching this court, great court, for almost 75 years now.
Okay. And so, was law always on your mind, or was there something else ever which?
No, legal scenario in those days was very limited. It's private law. Public law came into prominence after the advent of the Constitution. And private litigation was the order of the day in those days. And how it developed in the last 75 years is perhaps the most exciting bend of Indian history.
Right.
It's the most exciting bend of Indian history, I tell you, because younger generation must know the great gift of democracy.
Right, sir.
Great gift of democracy. It's not mere words. It's a change of the whole human destiny.
Right, sir. Do you remember anything about your first legal case? Do you have fond memories of that?
Two things I remember very distinctly. I just entered the Munshi's court. And the first day, my father always insisted that I should undergo the trial work, not go into the appellate work straight away. The magistrate was a friend of my father, and I had a distinction, academic distinction. In those days, the legal fraternity of the bar was limited. Everybody knew everybody else. And the Munshi before whom I appeared was very sympathetic. Some other case was going on. He stopped the argument and asked me the question that arose in that case. I think I answered it correctly. It was a purity of estate or purity of contract, whether a sublessee is bound by the terms of the main lease deed. What is the purity of estate or purity of contract? The very first case, very interesting. And it was a closed circle. The judiciary and the bar were in very proper terms. Not See, the sense of propriety the lawyers observed in those days were very high. Nobody would answer, no respondent would have a right to talk unless he was called upon by the court. The discipline was when you met a judge inside the chambers, you must be dressed. You must be in your robes. You can't meet in an informal dress. These are all the codes of conduct that lawyers observed. In court, a respondent could never stand up and answer unless he was called upon by the court.
Okay, sir. Okay. And so lawyers and judges are often perceived as serious people. So was there any moment where you could not control your laughter in court?
Very instance. A courtroom is something, the laughter and humor in courtroom is the most exciting, redeeming feature of the system. There was a lawyer who used to ask for adjournment at every stage.
Okay.
And he would always say, some unfortunate instance, somebody had an accident, somebody went to a hospital, somebody went into something. When he stood up, the judge, he said, today no inauspicious crowd. Tell me something about a marriage or a happy birthday celebration. Tell me something positive, I'll give you an adjournment. Okay. Everybody was, that was a very cynical remark on the lawyer himself.
Right, sir. And sir, if you had to explain the Indian Constitution to a child, how would you do it in the simplest possible way?
See, tell a child that life of a human being without one power above them or one reason within them. It will be, this is the 16th century philosopher's statement of the human condition. Poor, nasty and brutal. Human life will be poor, nasty and brutal if it hadn't had one reason within it or one power above it. The author said, a pack of wolves is quieter and more at one if it had one reason in it or one power above it. This is the inevitability of one power above all of us. It's not a personal authority of any individual. It is the civilizational gift that we are controlled. We are slaves to the famous statement, we are slaves to the law so that we may be free.
Right.
We are slaves of the law that we may be free. And if you tell them that this is the reason why irrationality of everybody is rationalized by a common bond of human relations.
Right, sir. And sir, what is one incorrect perception that people have about judges?
Pompous, unkind, unsympathetic, rude. This is the image that popular persons have of courts. They have more fear than respect for courts.
Right, sir. And so what's the most bizarre or unexpected legal case that you've ever come across?
The Bhopal tragedy.
Okay.
Bhopal tragedy. There's an unspeakable tragedy, the combination of the avarice of the industrial empires, industrial leaders, and secondly, the negligence of the local authorities in not controlling the risk factors. How this could have been greatly mitigated if the authorities had followed strictly the norms against such hazardous industries.
Right, sir. And sir,
tragedy.
Right.
Unspeakable tragedy.
Right. And sir, when you were sworn in as Chief Justice by Sri Narasimha Rao, I'd heard that he had said that the relationship between the judiciary and the government should be cordial, and you said that it should be correct. So can you elaborate on that statement, please?
It is that episode is exaggerated.
Okay.
I said it more in humor than seriously. Okay. That I would rather be proper than cordial.
Okay.
I would rather have it rather proper than cordial. And he also he was a great statesman. Everybody, the tense silence for about 5 seconds after that. He broke the silence by saying, "You have all the propriety and cordiality." And he was a very statesman-like man.
Right, sir. Okay. And sir, your tenure as a Chief Justice saw landmark judgments that shaped the Indian constitutional law. So, how would you describe your judicial philosophy in one sentence or more?
Personally, very rewarding. But in terms of the court's contribution to the development of law and protection of democracy, maybe people have different opinions. And in my personal view, Supreme Court has done an enormous job with the kind of limitations that they have. They have an enormous job. Though the very first case, Gopalan fell short of the expectations of constitutional lawyers,
Okay.
and it required almost 27 years to correct it. And there's I think, the beautiful dissent by Justice Fazl Ali there.
Okay, sir.
Even B.K. Mukherjee, great judge, one of the greatest judges of all time, he signed on to that philosophy. If the cook of the Bishop of Rochester was ordered by law to be boiled in oil, so be it.
Okay.
This is what they said.
Right.
And the positivist definition of Article 21 of the Constitution, of course, subsequently a great change has occurred. You see, there are three phases in the working of the Supreme Court. First 15 years was a precedent-ridden court. There were great precedents in the Privy Council. It's a great institution. That was the first stage where they laid down solid principles of civil law. Then came the innovative stage. The four judges, Krishna, Bhagavati, Desai, and Chinnap Reddy, very fondly called the Gang of Four with great affection.
All right.
They brought in a remarkable change in the scenario, in the legal scenario. Bhagavati's contribution was enormous. In fact, I wrote a fetch in one of his fetch ships brought out after his passing away. I wrote an article. I think it's headed Bylanes of Justice.
Okay.
Highways and bylanes of justice was the commentary that was made, and Hidayatullah was very critical about it.
Okay, sir. And sir, how do you balance the fine line between judicial activism and judicial restraint?
Judicial activism and restraint are two faces of the same thing, two aspects of the same thing. You can't, judiciary doesn't have this stock of economic and social wisdom. Judiciary doesn't have the stock of social and economic wisdom by which you can say the law is good or bad. That's why great Judge Holmes in American court said, if judicial review is taken away, America will not come to an end. If judicial review is taken away, America will not come to an end. He said, I don't have the stock of social and economic wisdom by which I can say this law is good or bad. I'll say what the crowd wants is what we want also, what the crowd wants. Not the populist, it is the majoritarian. Populism is not the issue. In regard to issues of perception of what is wise or not wise, what is foolish, people know better. A handful of unelected, non-accountable judges can't say, according to us, this is wise for you. Wisdom or foolishness is the privilege of the people. I say if it is constitutional or not is all that I could say. That's the limitation on the judicial activism.
Right. So, and so, what's your view on the evolution of public interest litigations? Do you think they have strengthened democracy or have they been misused over time?
It's a very difficult question, but Bhagwati's innovation of the public interest litigation by reducing the threshold entry of locus standi in enforcement of constitutional rights was the most remarkable exercise for access to justice in any jurisdiction anywhere in the world. I'm totally, personally, I admire that innovation so greatly because for a country with such large population and so much of ignorance, providing a venue for people to agitate on behalf of the crowd, the lessening the locus standi requirements. Formerly, if you want to go to court, you have to prove your bona fides about locus standi. Who are you? Now a man can say, I am the people. I come to you on behalf of the people. Of course, there will be, in working out any system, there are problems. But by and large, that has opened up, it has opened up the mind of the bureaucracy that there is a court which will check us. Mind of the politician that we are under scrutiny. That itself is a great contribution to democracy.
Right, right. True. And so, when writing a judgment, how do you decide how much to explain for future interpretation while still keeping it concise?
It's a very beautiful question. Beautiful question. It was answered partly, or perhaps somewhat convincingly, 100 years ago by Dean Roscoe Pound. He delivered 3 lectures, Theory of Judicial Decision Today. This is a mathematical proposition. I start a mathematical proposition by working out the steps one after another, but I don't know when I commence what the result will be. Work out a mathematical proposition. I start one by one, step by step, and ultimately I come to a logical conclusion which the logic takes me there. Judgment is not that, it's already in your head. You are providing justification in paper for that. And the mind is made earlier. And you give reasons to convey why you have come to that conclusion to the public. That's the theory of judgment.
Right. And so, you were a part of crucial rulings on constitutional law, fundamental rights, and governance. Which judgment do you think had the most far reaching impact on Indian democracy?
I think the accession of Sikkim to India, which by majority Supreme Court decided in favor of the accession. And of course the Bhopal case, where very many issues of private international law came up, and Justice Keenan's order in the American court. I think from the point of view of effect on the public, Bhopal case was really the case that gave us a lot of anguish and
And so, the interpretation of fundamental rights is constantly evolving. Do you think courts today are expanding them too much, or is it a necessary evolution?
the art of adjudication. How is a 200-year-old document in America being cited as the foundation for decisions today? Everything has changed. The constant words, the interpretation of the constant words of the Constitution, applying the constitutional intent to a present situation is the word is a whole whole range of judicial thinking is involved in it.
Right.
The whole range of judicial thinking is involved in adapting the old world, 200-year-old words uttered 200 years ago to a modern situation. The words are the same. The meaning is different. Meaning is evolving. That's why they say there's a purposed vagueness in the language of the Constitution. It's the purposed vagueness,
Right. So,
so that it could be applied from interpreting the constant words, printed words, to different situations. That's the genius of the court.
right. So, true. And so, what was the biggest moral dilemma you faced ever while deciding a case, if any?
See, I find even today a little confused about 30 years after a big crime is committed. The whole situation, the life patterns have changed, life has moved on. We sentence a person to jail after 30 years. And you see, this happened when a young boy was, an 18-year-old boy was sitting in his father's shop when the father had gone for lunch. He sold some provision, some condiment. He was prosecuted for adulteration of food and convicted after 25 years and sent to jail. He was a boy of 18 years, and by the time he had married and had children, and they went. That was a dilemma, but I couldn't change the conviction because it is prevention of adulteration of food is a social defense legislation. It must be strictly applied. So I convicted him. Then my brother judge was a very sympathetic judge. How do you send this boy to jail after 30 years of litigation when the whole thing has changed in his life and in society? Then I said, well, we'll appeal to the state government to remit the substantive part of the imprisonment and confine it only to fine. State government happily complied with our request. They said, ask the state government to remit this sentence, though we convicted. These are the kind of dilemmas that haunt every judge. There is some endowment of the Punjab legal fraternity, some justice in memory of some Justice Sahani or somebody, some judge, Bhodraj Sahni Memorial Trust. I was asked to deliver the address the lecture that year. The subject matter was effective delay in criminal trials. I pointed how both pre-council and the House of Lords had different opinions of it. How in Indian courts also, in principle, said undue delay in trial is a violation of fundamental right of the person. What is the delay? What is undue delay? How do you? This is a matter which is important for the law reformers to deeply consider. This is one area which is always a bothersome thing. In fact, when a young boy of 18 years being convicted after 25 years or 30 years, when you become a married man with children, go to jail for 2 years. But in that case, the innovation of an appeal to the government to remit the substantive part of the sentence worked.
Right, sir. Right. And so, given the current scenario on judicial appointments, do you believe the collegium system should remain, or do we need a better mechanism?
Alexander Pope once said, for forms of government let fools contest. Whatever is administered best is best. for forms of government let fools contest. Whatever is administered best is best. The, the product must be good. The selection must be good. And whether it is the collegium system or at one point of time, the Chief Justice, the Lord Chancellor would pick up anybody. In fact, there is so much of comment on Earl of Halsbury's law appointment. So adversely commented upon. And it was even put the humor against it, the cynical humor against the appointments went so far as to say the Punch normally left judges alone. They would not make any jokes about judges. David Lowe of the Punch, English humor magazine. It brought out a cartoon when in the judge's family there was a celebration. The child, the family asked the mother, what's the celebration about? She said, Daddy has been upheld in appeal. Daddy has been upheld in appeal. And the comment was that that judge was appealed against with uncomplimentary frequency.
Right, sir.
So there is so much of humor about it. And see, they are all evolving institutions. Things have changed a lot. And the pace of change is going to be alarming in future. What took 10 years for something to change will change in 10 days.
Right.
And the issue is how well prepared we are for the forces of change to be handled. I think there is a new scenario will emerge where lawyers, technologists, scientists will all have an important role in shaping the institutions of the future.
All right, sir. All right. Okay. And sir, you've played a very important role in anti-corruption laws. So, what do you think about how corruption cases are handled in India today?
There is increasing awareness of the need to stem corruption. There is increasing awareness, but the mechanisms are not very adversarial system of law enforcement. For example, two reports suggested some change in the concept of presumption of innocence. One was, I think, Lord Runciman of Doxford, report of Lord Runciman of Doxford in Britain. He said presumption of innocence. English jurist once commented, if all the criminals of the world had a conference, first resolution they would pass would be in favor of the presumption of innocence. But that's the cardinal thing, of the vital thing there. And Justice Malimat Committee report also slightly suggested there must be a relook at that. Presumption of innocence. And Runciman's report, which was lost its great weight, otherwise a very good report. I think in the 1990s it came up. Then came the civil justice reforms of Lord Wolfe Committee in 1999.
Right.
In India in 1924, there was that famous judge in Bombay High Court who went to pre-counsel. 1924, a committee report in 1972, I think there's the Arrears Committee, as it is called, 1972, there's a report, and so many things have been done.
Okay, sir. And so you've been vocal about the credibility of institutions. How can the judiciary regain public trust at times when it is questioned?
So, the bridge between performance and its acceptance, public acceptance, is a very delicate issue. public opinion itself, as one great philosopher called it, public opinion itself an impalpable congeries of hopes and fears. Is an impalpable congeries of hopes and fears. And how authentic is public opinion, how it is ascertained. In future, the biggest issue in democracy will be how information systems will be managed or mismanaged by vested interests.
Right. Right, sir.
That's going to be a big issue in the next stage of our democratic exercises.
Right, sir. And so, what have you noticed that what's the big difference between the Supreme Court during your tenure and today's Supreme Court?
The emphasis on issues are different. Things are forces of democracy are reasserting themselves. Though wisely or unwisely, I think people are aware of issues of public concern. I think personal rights, personal liberty issues are coming up. Privacy judgment is a remarkable judgment. Justice Pursami case was a remarkable judgment. The people must study the judgments. They are written very carefully, and they are very good judgments.
Right, sir. And sir, the number of constitution bench cases has drastically reduced over years. So, do you think we should have more frequent constitution bench hearings?
That's the purpose for which the court is set up.
Right.
If you see for example, if you see the number of writ petitions filed under Article 32, there is no comparison. There are hardly 100 or 200 in a year. Not even that. While the filings are, in 1 year, it was 75,000 cases, other matters. Compared to the filing of SLPs or other kind of Article 32 petitions are very small. Yeah, of course, it's not the number alone that matters, but that's an indication that the Supreme Court was meant to be supreme, the constitutional interpreter and protector of personal liberty. And Article 32 presents an indication how people are looking at the Supreme Court for this. It's hardly 100, 200 per year, while in 1 year they filed 77,000 SLPs. And my goodness, how they manage this is a miracle, Baba. I tell you, the American court decides about 130 cases a year. The pre-council decides about 60 matters. I think the Supreme Court of England may decide about 60 to 100 cases a year. And the Supreme Court of India lists 1,000 cases every week.
Right. And so, if you could go back in time anywhere in the world, and you had the option to witness one historical courtroom trial, which one would it be and why?
What did you say?
If you could go back in time, and you had the option to witness any historical courtroom trial in the world, so which one would it be and why?
I would go back to Cope's trial in America. In the 20th century, a teacher was prosecuted for teaching Darwinism and evolution as for the offense of blasphemy.
Okay.
It's a remarkable thing. In 1842 or somewhere there, the American Supreme Court said, we are a Christian country. Christianity is a part of the common law. That link between religion and law, religion and democracy, religion and state.
Right.
was that umbilical cord was cut in that case, in Scope's trial in 1926 in the American Supreme Court.
Okay, sir.
It's a remarkable trial where a man who taught Darwinism and evolution was prosecutor of blasphemy. Clarence Darrow, the great lawyer, defended him, and the cross-examination was something with extraordinary case.
All right, sir. And so, if cinema or literature were to accurately depict the life of a judge, what is something they always get wrong?
They always get wrong, that's true. There are many reasons for it.
But what is something you've noticed they always get it wrong?
They perceive it as wrong, but perception is different from reality.
Right. But I mean, I'm saying when we see a film and we look at a judge in the film, what is wrong? What do you think? Like, what is something they get wrong about it? How?
Both are wrong.
Okay. What makes you say that?
There is some dissatisfaction in the matter of expectation of the public from the courts. They want dramatic things. Courts are not able to offer that. Very interesting question.
Okay, sir. Okay. And sir, if you could change one rule in the legal system overnight, what would it be and why?
This is purely hypothetical because I don't
Purely
have
hypothetical.
now the prospect of having such a role in my life again. But I would answer it with some kind of a concern in my heart. We could have mismanaged this system much better. And today, nobody owns the problem. Judicial arrears, government says it's the role of the judge, the Supreme Court, or the Chief Justice. Chief Justice says it's the role of the government. Everybody says nobody owns the problem. And I would earnestly request the Bar Council of India, the National Judicial Academy, the Chief Justice of India and the Chief Justice of the High Court, they can solve this problem with the help of technology in a very, very, very big way.
Okay.
In fact, Lord Wolf's report, they brought about great changes in England. And the lawyers, trial lawyers in the trial case must have a conference with the judge to have a schedule of procedure. How you plan the case, the future steps of the case that you plan together and adhere to it. It's possible to do it. It is the systems men, computer systems men. They can provide an answer for this, and they will see the judicial. It is not judicial work; it's judicial management of judicial procedure.
Right.
Case flow management is a technical work. It requires systems men. There are great men, great talent in this country in that regard, and you could solve this problem. You must have a new court from on and after this day. All the filings that are filed are put into a kind of a
System.
kind of a thing which will assembly line.
Right.
You plan, some cases go out of it and they will go to the long pending list. 95% of the cases can be disposed of in the assembly line pattern, and that will be managed by systems man.
Right. Okay.
The problem is some of them say a systems man is an outsider, you can't bring an outsider to the judicial system. You have your own systems man training, your own cadre within you. And and a new court and the old court. Old arrears will be dealt with by the old court in a self-resolving procedure. But the new cases filed on and after a particular date will go in an assembly line,
Right, sir. Okay.
managed by systemsmen who can be a part of the judicial system itself.
And these system men you're referring to would be from the judiciary or the system men?
Computer systems men, they
yes.
will manage. There is great talent in this country. There is Nandan Nilekani planned this Aadhaar system for the country. The whole world is looking at it with wide-eyed wonder how they are able to manage that. There's Tata Consultancy Services. There are a number of people who can manage. For example, whole income tax system is being managed by outsourced to industrial houses. I think Infosys company or Tata Consultancy Services are doing this for government.
Right, okay.
Yeah. This is very important, sir. This is very important. And 30 years for litigation, a man's lifetime is gone.
Right, sir. True. True. And as you mentioned technology, I would like to ask you that if artificial intelligence were to replace lawyers in the future, what's one thing that artificial intelligence will never be able to replicate about being a judge?
See, one good thing about artificial intelligence is you and I know what we don't know. A man knows what he does not know. Artificial intelligence does not know what it does not know.
Right.
It knows only what it knows. There is a great scope for utilizing it as a good servant. Don't make it a bad master.
Right, sir. True.
The scope, the future of artificial intelligence is immense. You can't predict it now. And the danger is the technological singularity. You can't switch off artificial intelligence against its wishes. You can't switch it off. You can't, like a computer, you can't switch it off. One computer speaks to another, another to a third speaks to a satellite, the satellite speaks to somebody else. You don't know who is controlling whom.
Right. True, sir. Right.
And there is an old story of a man who wanted some genie to come and work for him. And somebody brought a genie to him and said, this can do any amount of work for you, but don't keep it silent, unemployed. It will eat you up on one condition. If you keep him silent, he will devour you. He said, no, I have so much of work, let him come and I'll engage him. He had 1,000 acres of land. And he told the genie, in each, separated to 1 acre plot each, 1,000. Dig a well in each acre, plant a different crop in each of the 1,000 acres. And he thought, I've given him work for 10 years, let him come back, let me see. And he turned back. The genie said, done, I've already done it. Then he gave a shriek of shock. What else could you do? Otherwise the condition was he'll eat it up. Then his wife came and told him, I told you not to engage this fellow. Now you have done it, you have to face it. Ask him to obey my orders. He said, I'll do what she wants. He said, the genie turned to her and said, where is the work, where is the work? She gave a small puppy dog and gave it to him and said, straighten its tail. The fellow sat together and he did that and it could and he disappeared. This is the story about the artificial intelligence.
No. And so, looking back at your career, is there one ruling or legal reform which is not spoken of much and you're really proud about?
Many rulings of the Supreme Court qualify for this kind of situation. There are many things which are very pious and well-intentioned. But, for example, the, the protection of women in workplaces, the law that was made, and there are a number of things which are of immediate concern to the day-to-day life of people. But we can't say executive is negligent and they don't have the bandwidth, intellectual bandwidth, physical bandwidth to deal with these things. There's a mismatch between resources and responsibilities. How to assign? You must be realistic in your estimate of the performance capacity of the executive.
Right. True, sir.
There are big problems for administration, big problems for administration. It's not some kind of administration is not some kind of a machine you can wind up once in 100 years, it will tick on for 100 years. No. It requires day-to-day intervention.
True, sir. True. And so, how do you see the future of the Indian judiciary? If you were starting your legal career today, would you still become a lawyer?
I don't know whether I would have the energy and the imagination and the freshness of emotion to accept a lawyer's job today. It will be the most demanding job, intellectual job. It will stop being a routine kind of thing. See, we are got accustomed to sequential processing. Sequential processing, one stage, next stage, and all that. The now demand is synchronous processing. The order of sequential order will change. It will be reversed. It can be parallel. So a combination of intellectual abilities and the management techniques and the systems that are available, a combination of this kind of thing is the work of a genius.
Right.
Many things are possible today, particularly in the field of dispute resolution. Many things are possible. And in future, the institutions can't manage the intellectual challenges of the scientific development. The intellectual challenges of the scientific development of the future will make it impossible to bring them within the present state of systems. It requires new methods of management, new ideas, new institutions, and the future issues that arise in legal conflicts require different kind of expertise. Different kind of expertise, and a combination of legal minds and scientific minds, and unimaginable kind of complexities will be confronting the judicial system.
Right, sir. True. And so, what is one question you wish people asked you more but never do?
People are becoming more and more aware of the possibilities and the actualities, the gap between what is really possible and what is happening. How to bridge that gap? And society is more inquisitive today, more demanding, more expecting than any time in human history. And what we forget is, it is not the top leaders that misguide people. It is the susceptibility of a human being, his intellectual, neural susceptibility to be swayed away in an unthinking way, swayed away by a hero worship, ideal of hero worship, an ideology for a religion, for a cause, for a slogan, sacrifice his life for that. It is the unthinking devotion of an individual to a cause like this, emotional susceptibility, that is more harmful than a bad leader.
Right, right.
Thousands of people die for a particular cause without knowing what the cause really is. This is the dilemma of man. There's a beautiful lecture on that by a neurologist, Human Brain and the Dilemma of Man. That is the impact of the pattern, the evolution of the human brain itself, which makes a man susceptible to this kind of hero worship, unthinking devotion to a cause, symbol, or a slogan. Sacrifice his life for that. That is more dangerous to future civilization than the misleading capacity of a leader.
True, true. And how do you think so? This whole thinking of hero worshipping can, like, how can people let go of it? Do you?
This is very human nature itself.
Yes.
There is a responsibility for leadership to provide wise leadership. This is the responsibility today. When people go, see, anything can catch up in a wildfire manner. His man's unthinking devotion to a cause, for a leader, for a language, for a symbol, unthinking devotion. And that has been the cause of thousands of people who have sacrificed life for a leader. Leaders have never died in warfield. It is the soldiers that have died. And this is a state in which there is a responsibility for the state in the abstract sense to provide some safeguards for these things.
Right, sir.
This is the result of the hierarchical development of the human brain itself.
Right.
There are three stages of the brain in the course of evolution or millions of years. The development of the human brain itself has been the cause of that.
True, sir. True, sir. And okay, sir. If you think so, if you had to rewrite one of your judgments today, which one would it be? If and why?
Happily, I have no opportunity to do it now. But all the judgments require conclusions may be right, but the reasons are revealing now, coming up now, either in favor or against it. That's why life of law is not logic; it is experience. The famous statement of Holmes: "Life of law is not logic; it is experience."
That's all. And if you had to sit on a 5-judge bench today with any 4 judges from history, India or global, who would you choose?
Judges.
Judges. If you had to sit on a 5-judge bench today with any 4 judges from history, India or global, who would you choose?
First is Justice Holmes,
Okay.
a great judge. Then Sir Ashutosh Mukherjee. Sir Ashutosh Mukherjee. Sir George Rankin. Lord Hobhouse
Okay, sir.
of the Privy Council. And Krishna Iyer.
Okay. Okay. And any reason, any specific reason why would you, like, why did you choose them?
They have diverse civilizational perceptions which could be assembled into one essence, distilled into one essence. That will be the greatest gift to humanity. They are so diverse.
Right.
And if this diversity can be distilled into one common good, That's the finest panacea.
That's true. And sir, if in India, hypothetically, if India were drafting a new constitution today, what's one thing you'd change or add that wasn't in the original?
I would not alter anything in the Constitution.
Okay, sir.
I would alter our attitude towards it.
Right, right. Okay. And so my second last question to you is, how old were you? How old are you right now? Can you share with us?
I am 96.
And what's the secret to your fitness, sir?
People, friends like Basen
Okay.
and and the dimensions of my curiosity.
Okay. Okay. And sir, my last question to you is, if young law students today ask you for golden words of advice, what would that be?
I would only repeat one word which Lord Frankfurter, Justice Frankfurter, told an aspiring law student. Come to law as a well-read person. Come to law as a well-read person. Read well, think well. Don't think of the future, your own future. Be a cultivated man. A dutiful man. A man who accepts the great gift the Lord gives you with and trusts in your spirit. Be a dutiful man, a cultivated man. Come to law as a well-read person. I think in one of his books, Folly has repeated the advice of Frankfurter to an aspiring law student.
Okay, sir. Okay.
Read well, think well, don't think of your own future. Come to law as a cultivated person, a well-read person.
Okay, sir.
Keep your dimensions of curiosity open.
Thank you. I think, sir, there would be no better note to end this interview. So thank you so much for your time. I hope you had a good time, and we did not trouble you much. But thank you so much for doing this for us.
Thank you, thank you. Fantastic voyage,
Okay.
like Raymond Kurzweil. He says in this century, the minimum age is 150 years. And he gives a prescription for that. And he says, how do you add? He says you can add 1 year to your lifespan every year. And how do you do that? He says, change your sugar, white sugar, cane sugar into stevia sugar. Change your cooking oil into a fish oil or olive oil. Drink 9 cups of green tea and maintain the physiological alkalinity of the blood. You will add 1 year to your lifespan every year.
Roll another.
I must thank all these young friends who tuned
Thank you so much, sir. Thank you so much.